Good afternoon. My name is Jennifer Levi, and I'm the director of the Transgender Rights Project, Gay and Lesbian Advocates and Defenders. I'm also a professor of law at Western New England College. I testify in strong support of House Bill 1728, Senate Bill 1687. If I may, I'd like to start by addressing some of the objections that have been raised to the bill. In particular, I'd like to address the distortions of the existing case law, which the prior opponents to the bill would suggest undermine in any way public safety in restrooms. Nothing could be further from the truth. What the previous testifiers neglect to mention in the main experience is that there was a companion case brought to, on behalf of a non-transgender student, a biological male student who did seek to use the girls' restroom. And in that case, and I'm quoting from the Maine Human Rights Commission decision, the Maine Human Rights Commission decision said that the boy who attempted to use the girls' room was not protected by the comparable state law. In the words of the Human Rights Commission, the school argued, and is correct, that the boy student was disciplined not because his biological sex is male and he used the girls' bathroom. Rather, that boy student was disciplined because his biological sex is male and his gender identity is male, and he used the girls' bathroom. That case reflects the complete workability of this law. The transgender girl who had been using the bathroom unproblematically for 4 years and was only prohibited from using the girls' bathroom when the school was contacted by the media, who was contacted by the boy's grandfather. So when that transgender girl was kept from using the girls' bathroom and brought a case, the Maine Human Rights Commission said that the law protects that transgender girl student. It doesn't protect the boys' student's ability to use that bathroom. Moreover, none of the issues around safety, including in the BU context, involve transgender people. I'm a parent. I have 2 small children. I worry about their safety every day, including when they use public facilities. I don't worry about their safety from transgender people. I worry about their safety from predators. Nothing in this law undermines the criminal prohibitions against a man who would go into either restroom, male or female, in order to perpetuate a crime. It's simply a distortion and a misrepresentation of the law. I also want to address 2 of the other issues that were raised, including the religious exemption question. This law doesn't change the established religious exemption from non-discrimination laws. It's a well-settled question in Massachusetts and under the First Amendment that if someone is involved in a personal interaction, they need not violate their personal religious beliefs. On the other hand, if you're a store and you open your business to the general public, you don't get to pick and choose among customers on the basis of their race, on the basis of their gender, on the basis of their sexual orientation, or other areas of prohibited discrimination under the law. The same is true with respect to the hate crimes law. We have a hate crimes law in Massachusetts. It's a well-settled question about its constitutionality. All this bill would do is add gender identity and expression provisions to ensure that when transgender people are attacked, as they have been, including in Lowell most recently, that data is collected, that the Attorney General can issue a civil rights restraining order where they are where individuals are harassed, and there can be prosecutions that affect the impact that has on the entire community when someone among the transgender community is assaulted. Nothing in this bill changes the law whatsoever in terms of the existence of our current hate crimes law. I'd also like to address, if I may, more broadly, the issue of any impact that this law has on the workplace. This bill is in place in 13 other states, including the District of Columbia. Major employers, including among the Fortune 100 and Fortune 500, have non-discrimination provisions that ensure that transgender employees can work despite the prejudice and discrimination that they face in the workplace. The bill does not change the law with respect to an employer's ability to enforce reasonable appearance and grooming requirements. And to the extent that the court permits it, it does not change the ability of an employer to have a gender-based dress code. It only ensures that transgender people can appear in the workplace consistent with their gender identity and with their gender expression. This law is essential. It is workable. The bill completely tracks its existence in 13 other states plus the District of Columbia. And in summary, and on a personal note, this bill is of critical importance to me. I am a person who does not fit the stereotype of what a woman should look like or to some of what a man should look like. It's critical to me to have our laws state clearly and distinctly that other people's discomfort and misunderstanding about my life should not limit my rights of full citizenship. I thank the committee for consideration of this bill.
Thank you. There's a question. Yes, Senator King.
Thank you, Madam Chair. Professor Levi, you seek to codify a decision of or a ruling of the Mass Commission Against Discrimination, a ruling that is already in place with the MCAD. Could you tell us a little bit about that case and what that ruling is about? And also, many witnesses have testified that the law already, the Massachusetts statutes already adequately protect transgendered individuals from discrimination and abuse and hate crimes. Why is that not the case?
Right, I appreciate the question. Federal law and state law has been moving in a direction of protecting transgender people under existing sex discrimination prohibitions. And so, for example, there was a case that went up to the United States Supreme Court in which a woman who was up for partnership at Price Waterhouse was denied partnership because, in the words of the partners who were evaluating her, she didn't present sufficiently as a woman in the workplace. She was described as being too aggressive. She was told that she should wear makeup and stockings in order to fit better into the workplace. And the United States Supreme Court said that that kind of enforcement of sex stereotypes, including of women in the workplace, is prohibited under federal non-discrimination law. It's based on that interpretation that many states, including Massachusetts, at the Commission Against Discrimination have said that existing laws protect transgender people from discrimination. And so it is true that the MCAD accepts claims on behalf of transgender people. Notwithstanding that, there are many employers who don't understand the full scope of the law or, quite frankly, disagree with the scope of that law. There is a decision from the Superior Court that affirms that interpretation, but there's no Supreme Judicial Court interpretation of that law. This bill would seek to codify that, to provide clarity not just to those of us who would be protected by the law, but to those employers who would be subject to it. And it is just the kind of misunderstanding and misinterpretation of existing law that underscores the need for this codification.
There was another question, Representative Gary.
Thank you. I'm concerned about the vagueness of the terms gender, identity, or expression, or behavior. Could you explain what the differences are and where do you draw the line?
Sure. What the bill does is, as I've said, is to incorporate language from other jurisdictions to ensure that there's a developing body of law that will enable the courts to interpret just the kind of line-drawing questions that you may be concerned about. That term, gender identity and expression, is a legal term of art that a growing number of courts across the country have interpreted to apply to those individuals whose identity and expression related to their gender is firmly held and manifested in a way that is commonly understood. And so it needs to include characteristics because of a concern that employers that are subject to the law, for example, would look at biological markers which may not be reflective of a person's gender identity. And as I was saying, the cases in Maine demonstrate the workability of that standard. And the reason the language is what it is to ensure that to the extent that questions are raised, our courts and the Mass Commission Against Discrimination can look to decisions that are issued by other human rights commissions and other courts in properly interpreting that language. Same questions have come up, just to most fully answer the question, in the context of race discrimination prohibitions, disability discrimination prohibitions, religious discrimination prohibitions, and the law is drafted in a way to ensure that courts can interpret that language consistently and in a narrow way that reflects individuals' core and deeply felt sense of who they are as male or female.
Just as a follow-up, I do agree with a couple of the previous speakers. I have a real concern, and I want to say it point blank, I don't believe that transgender people would be pedophiles or would injure anyone. But the fact that we have pedophiles out there that could dress like a woman and go into a ladies' room and use that opportunity, and how do you suggest that we fight that?
And I share that concern, absolutely. I think it's very real and it's a very significant concern. The reality is that someone today could try to dress up convincingly, go into a restroom, and inappropriately prey on someone who's vulnerable. There's nothing in the law today that prohibits this, and there's nothing in this law that enables it. So to a certain extent, that concern is out there. It remains out there. It's the reason why we need to have robust enforcement of our criminal laws. And the reality also is that transgender people do use restrooms and do need to use public facilities. And so what this law does is provide predictability and clarity for those individuals that manage those facilities. But to the extent that that's a concern, I fully agree with you. I do want to say that the major women's organizations in the Commonwealth, including the Boston Rape Crisis Center, including the Massachusetts Society for Prevention Against Cruelty to Children, including Jane Doe, Inc., that is responsible for ensuring and providing for the safety of sexual assault victims. Massachusetts now, there's a list of it in my testimony, have all spoken in support of this bill. And I will say that part of the concerns that they have raised is that the opposition is suggesting that if we presume, for example, that transgender people cannot use the appropriate facilities, that women will be safe. And I think that those organizations are concerned about the distraction that those kind of objections present to public safety officials who should be appropriately responding to predatory assaults, predatory individuals and other people who would seek to assault women in the restroom. It really is a distraction. There's nothing in the law that enables that or makes it easier for anyone to go in and assault anyone else. And we share your concerns as well among the transgender community.
Thank you. Thank you, Madam Chair.
Yes. Yes, sorry.
Thank you. Thank you for your testimony today. I wondered if you could tell me, as a former school committee member, I'm interested in the case out of Maine. If you could tell me sort of about that case, and was the child who was allowed to use the girls' bathroom, was that something that was allowed preceding the Maine statute change, if you know?
Yeah, it's reported in the decision that the transgender girl had been using the girls' restroom since the 1st grade. It wasn't until the 5th grade that there was any concern raised by the school, and it was upon the instigation of the grandfather of the boy student. The girl who had been using the restroom since the girls' bathroom since the 1st grade was determined by her parents and by the mental health care workers that she had been working with that her ability to use the girls' restroom was essential to her well-being, and no other students ever had a problem with it. I will also say that in 2001, I represented a transgender 11-year-old in the city of Brockton who was similarly denied the ability to attend school and present herself consistent with her female gender identity. In that case, the Superior Court ordered the Brockton schools to allow her to present consistent with her female gender identity. Once the school was ordered to do so by the court, she was able to present unproblematically. No school administrators had a problem with it, and no other students did either. And I will say that there are many schools throughout the Commonwealth that are appropriately addressing the concerns of the transgender youth in our cities and towns. What this law would do is provide guidance to those school administrators and provide clarity so that schools could appropriately address those issues. In the Maine case, provides exactly a model, in fact, for other schools to look to for an elementary school that had been addressing the emotional needs of a transgender student for many years.
Would this law change any requirements in school curriculum?
There's absolutely nothing in this law that requires schools to teach anything specific with regard to transgender young people. It does not address curricular issues whatsoever.
One more question. I have heard some question from employers about whether this change in law would have any effect on employers who require certain uniforms for employees.
Right.
Can you answer that question?
Yeah, this bill does not change any otherwise permissible workplace appearance requirements. It does not in any way impact an employer's ability to enforce uniform requirements, and as I said, to the extent that an employer may enforce gender-based dress codes, it only ensures that transgender people can present in the workplace consistent with their gender identity or their gender expression. And again, I'll say that there are major employers, including Microsoft and Bank of America, Federal Express, most recently a Tennessee-based company, that include non-discrimination policies within their human rights policies and have been able to administer their requirements consistent with their own non-discrimination policies, which are above and beyond the legal requirements in the states in which they exist.
Some earlier testimony we heard today also talked about that this bill could impact veterans and their rights under the discrimination laws. Can you address
Right, I appreciate the opportunity to clarify that. This is a 31-section bill which changes a number of different provisions under the law. There was a cut and paste error that was made at the time that the bill was submitted. The sponsors have agreed to formally make that technical change, and I think the opponents even acknowledged that that was just a technical cut and paste error, as I'm sure all of you know in the filing and in the reviewing of many of the technical bills that you consider, that those errors can easily be fixed and will be fixed. The supporters intend to eliminate no existing protections whatsoever.
Thank you.
Any other questions? Yes.
Who undergo medical transition in a particularly prescribed way. So there are some people that have an understanding about transsexual people that includes a medical orthodoxy about transition, if you will. So some people who transition have surgery, live full-time as the other gender, and undergo long-term hormone therapy as part of their transition. That is not true for every transgender person, just as it is not true for every transsexual person. In fact, the international organization that has issued guidelines relating to transition recognizes that the medical care for transgender people is on an individualized basis. So the concern is that if there was a bill that exclusively prohibited discrimination on the basis of gender identity, that it would be interpreted in a narrow way only to recognize those transsexual individuals who go through that, what's characterized as a triadic therapy. The incorporation of the term gender expression within the context of the bill is intended to reflect the fact that there are other individuals whose characteristics, whose expression, if you will, don't meet that orthodoxy and should also be protected by the bill.
Another question?
Madam Chair.
Yes, please.
Question for you relative to the provision that amends the sex discrimination statute such that it currently allows discrimination in places of accommodation for restrooms, health facilities, and the like based on the biological sex of the individuals involved. This bill would remove that exception to the extent that it would protect gender identity as a reason to utilize the facility of choice.
Other jurisdictions, 13 other states plus the District of Columbia, this issue is comparably exists and has never been raised as a concern or as a problem. I think that with all due respect, I think that there's a part of the question that suggests perhaps the immodesty of transgender people, or an interest or an intent to be disruptive in those facilities. I think that the reality is that transgender people, including transgender women, want to have access to women's gym facilities because they prefer that oftentimes, just as other women do. And what the law ensures is that the equal treatment of those transgender women.
What I would say is, with all due respect, it has absolutely nothing to do with the immodesty of the transgender individual, but the modesty of the non-transgender individual, and whether the remedy in that situation is a private facility available to one or the other? And would that private facility availability even meet the requirements of the statute?
A gym facility operator would not be able to segregate necessarily a transgender woman from use and enjoyment of all of those facilities. And I think that I think that the question sort of suggests either intrusiveness or an intrusion on another woman's privacy in the facility. And again, we simply haven't seen it in other places. And every other state that has in place the same law has been able to administer this unproblematically.
Okay, thank you.
We have another question, Jim.
We, as you know, because of your background, we have a HealthWorks exception, and I think that's what you're referencing, and
Right.
that's what the exchange has been about. I'm just going to be very blunt,
Sure.
if I may.
You may, as the co-chair.
If I am a male, and I am in what is allowed under the HealthWorks exception to be a male facility, and I have an expectation, a constitutional right, by the way, under case law of privacy and a right to privacy that exists and is allowed under that Massachusetts HealthWorks exception to the law. And if a individual comes into the locker room and is not either from an anatomical perspective or an expression perspective subjectively considered by me to be a male, and I feel that my right to privacy, along with my right for joining that health club because it's a male-only health club, how would you answer the concerns that may arise from members of those health clubs or from other facilities of public accommodation that may encounter similar circumstances?
Right. So certainly it would be permissible for the facility to provide you a more private space than the one you're in if there's a reason why you find it to be offensive to be around someone else whose body you determine to be inconsistent with your gender identity, if you will. That is always an option, right? There's nothing that would require you to use that public facility. So, I just want to say that it's certainly true, right, that people have different bodies, and that we all probably have different degrees of offense to other people's bodies, and I think that's an issue probably for lots of people who use those facilities, and it's always an option for you to make choices about having a more private space to use, and that would remain true.
Thank you very much. It was very.
Thank you.
The next panel.